political context. Lastly, Your Honor, on this affidavit, I want to bring to the attention of this that it is only the judiciary that is going to protect Kenyans. A great responsibility is on this independent arm. The political dwells outside should not be criminalized. And we urge this court to sit firm and remove the political contests from criminal issues. This is a political matter before you. Deal with it the way it is. So, Your Honor, out of that 5 minutes I've finished, I allow the President of the Law Society of Kenya, before he removes me from the role of practicing, to talk.
Your Honor, with your very kind permission, I recognize the predicament. Yes, sir.
The President tells you what is happening, Your Honor, in this court.
Your Honor, I want to begin by saying I do not envy the position you find yourself, and neither do I envy the position that the prosecution finds. Your Honor, what you are being asked to do by the prosecution
they are lighted. Cause more harm. To the security of the country. I also wish to draw your attention to paragraphs 7, 8, and 9, and 10.
Unlawful assemblies taking place, which have led to destruction of property. And therefore, you know what the prosecution is saying for this court is that the compelling reason here is that even as we talk, or even as we submit before this court, there are certain acts of destruction that are ongoing. Your Honor, I hate to interrupt my very good friend Mr. Bingu, but you have limited time, and Mr. Bingu is actually giving evidence which is nowhere in the affidavit. And I know he knows that. I've tried to figure out, but my seat is becoming hot. I think let him just Here I've had my mandate for this. And then it is the hotness that we are stating that these are compelling reasons that the court should concede. Secondly, on the other, the time I have, the other authority that the prosecution wishes to rely on is the authority reported to Libya, Telagan Kipyotich versus the Republic. Criminal case number 001. Delivered by Sophie Emily Khalil at the High Court Clinical Commission. This particular authority gives us submission that again, one of the compelling reasons that we have submitted through our affidavit, and which is cited on the second page, is that again, the accused persons are likely to commit further offenses. And secondly, the accused persons, Your Honor, are likely to obstruct the cause of justice. Your Honor, under Article 24 of the Constitution, the right and the principles that the court highlighted this true authority to grant the prayers that we have so far today. That is all.
I'll just have a bit to address, then I'll invite my learned friends to address you on some few aspects. I will address you on the aspect of the pre-arraignment detention in respect of the first accused person to which the prosecution is guilty of, and further guilty of the duty of non-disclosure. You know, the first accused person was arrested on the 18th on the 18th at 0900 hours, that is 9 p.m. at JKIA when he was en route from Mombasa, 18th of July at 9 p.m. or thereabouts. He was then taken to driven all the way to Kirinyaga County and detained at a police station called Wamuru Police Station. While there, Your Honor, he was denied his rights to make any contact to either his family members or his advocates. He spent the whole day there yesterday. Never ever even informed of the reason for the arrest. You know, I'm addressing the violation of Article 49 as I address you. He was denied right to access to counsel. And most fundamentally, he was denied the right to be produced before a court of law within 24 hours. This is a time at around 5 o'clock that 5 o'clock on the 20th of July that the accused person has been able to see a judicial officer or to appear before a judicial officer. There's no explanation that has been adduced why all that transgression had to take place. It's only the duty of a trial court it's only the duty of the trial court to inquire on that particular aspect. As and when the same is brought to the attention of the court. You know, pre-arraignment detentions were outlawed, and Article 51 speaks to that fact. And the case in the court, the High Court in the case of Musa Wagwa versus Mwanasi and 9 others, for the Chief of Kenya Defense Force, EKLR, Musa Mwabwaga, that is MBWAGWA, Mwanasi, and 9 others, versus the Chief of the Kenya Defense Force and others, 2021 EKLR. That aspect of pre-arraignment detention was addressed. And the High Court said it was unconstitutional. And therefore, a charge that is premised on a violation of the Constitution, the court ought to interrogate the integrity of that charge and the propriety of that charge. Even in the affidavit that they have brought before you, They have not addressed that aspect. As a pen off, the court is called upon by Article 23, by Article 3, to defend this constitution. Article 10 enjoins the court to uphold the Bill of Rights and the rule of law and a just society. Article 27 enjoins the courts to ensure, Article 27 enjoins the court to ensure that there is equal protection of the law, equal enjoyment of the law, and equal benefit, and outlaws any form of discrimination. We need an answer. Why was Honorable Babu Owino not brought before court within the prescribed period? Number two, whether a charge that is premised, I'm pending off. Oh, sorry, Your Honor. The answer that we are seeking is why he was not brought before the court as decreed by Article 49, clause 2F. Number two, whether a charge that is premised on a violation of the Constitution has legal propriety, and whether the same can be the premises for denial of bail or bond. Mr. Okachi, the President.
Yes, Your Honor, I will start by indicating, Your Honor, that it is true that actually not only the first accused persons, but all the accused persons are being arraigned before you, Your Honor, outside the mandatory 24-hour limit. Your Honor, the 5th and 7th accused persons were arrested on Monday the 17th, day of March 2023. So that we are just shy of the 5 working day period, with the 6th and 2nd accused persons being arrested on the 18th, alongside the 1st accused person. Your Honor, we will not belabor this fact because we will pursue it at the High Court in terms of the violations, Your Honor. But that is important because it tells you a lot as to why we are even addressing you at this time, Your Honor. Your Honor, what has happened, and in a nutshell, there is a skit that has been written. And Your Honor, the duty of the investigators and with a lot of respect to the battalion of prosecutors, senior prosecutors, is just to ensure that these accused persons fit that skit. Your Honor, there is no iota of evidence that has been placed before you. Either through their affidavit, Your Honor, or the oral arguments that suggest that there is any compelling reason, Your Honor. None whatsoever. Your Honor, if you look at what they have attempted to indicate as compelling reasons, Your Honor, and that is from paragraph 7 to paragraph 12. Your Honor, you will see there's a repeated use of the word reasonably believed. Reasonably believed. But you're not being told, Your Honor, reasonably believed by who to sustain this particular very heavy averment. Who is this who is reasonably believing, and on what basis? You do not have that. Your Honor, in fact, maybe this may not go on record, but this is the first affidavit I've seen from, HSC Victor Juma Witi that has no annexure at all. The very first one, I've never seen. And that tells you there's nothing. Witi can never do such an affidavit. There's nothing.
You're not for clarity of record. The affidavit is done by the investigating officer.
If it is okay, Your Honor, but you read it for yourself, and I do agree he cannot do that. However, Your Honor, you will notice that even on the substance of the charge, Your Honor. Yes? it is my learning, but he has clarified, so I leave that point. But Your Honor, if you look at even the charge itself, to show you how they have actually stretched to the point of breaking a back, that is what the prosecution has done. Your Honor, they are telling you in very good English that these events happened on the 7th and on the 18th day of July. 18, 2 days. On the 7th day of July and the 18th day of July. That is on the particulars of the offense. And Your Honor, they are telling you further that these events happened at Kamukunji. Your Honor, and this is common knowledge even to them, they have admitted that Babu was, the first accused was arrested at JKIA. On the same 18th, at around 10, because he landed at 25 hours. So, Your Honor, the question is, do we have two Babu Owino'S? Does he have a clone that was at Kamukunji that day? Your Honor, it's able for the court's eyes, the ticket that says clearly he was landing at 21:25. Your Honor, if you look at further to demonstrate the fact that there is no compelling evidence, and indeed, even the substance of the charge is something that the court ought to look at in admitting the accused persons to bond. Your Honor, I'll refer you to paragraph 7. Your Honor, they are telling you, and my learned friend Mr. Ringo has told you that there are people who have been rioting or who have been picketing, especially where the first accused person represents that constituency. So that is the compelling reason we are being told. Your Honor, there is a decision or a ruling by your brother, and that is the Honorable Justice Mugambi. Your Honor, that is in the case, if I may, in the case of Edwin Sishana Amboso versus LSK and 4 others. We have provided that to yourself and to the prosecution. That is HCC petition 255 of 2023. Edwin Sishana Amboso. Your Honor, it says in order 2 and 3, and I want to wind up at that point, that it is the responsibility of persons who have announced and organized the say demonstrations to provide guidance and leadership to the participants. Your Honor, the first accused person is not even a principal in the Azalea coalition. He wishes he is a bit, he's not. And there is no evidence that has been given that he organized any of these protests. which in any case, Your Honor, remains legal. It remains legal because your brother declined to injunct the said expression under Article 37. Your Honor, Order 3 is also very important. It says acts of violence and destruction are personal, and the relevant authorities must deal with individuals. Acts of violence or destruction of property are personal crimes. So it cannot be a crime where vicarious liability, like the prosecution, is fine to appeal. Your Honor, the chart that has been prepared, Your Honor, the history of this chart is very important, and I think this court will bring this matter to a rest. Your Honor, the section 77(1) of the penal code, Your Honor, was brought into our laws, Your Honor, in 1960 as an amendment. So that it didn't originate from the Britons. It's something that was brought here by the Britons themselves. It wasn't in their own laws. And the purpose of that, Your Honor, was to ensure that this country does not get independence. It was to deal with the Mau Mau freedom fighters. That was the purpose of this particular session, that the DPP is actually telling us to use today. It was to suppress. So that is what this court is faced with in terms of this charge, Your Honor. It is to take us back to those days and those people who never wished this country to get independence. That's exactly the essence of this charge. And Your Honor, you will not find even authorities. I think people have been shy to use this section. You will not find authorities in terms of this section. Courts have been shy, prosecutors have been shy. But today, we are at the day where it can be brought in broad daylight. We will deal with it, Your Honor, at a different forum. As I finish, Your Honor, I would want to Your Honor, I will heavily beg you, and that's why I'm trying to limit this submission, Your Honor, to know that the first accused person, and I believe even the rest, but for him, he has not eaten, Your Honor, for 3 days. Not eaten, not taken water. 3 days. And because of where he was incommunicado, 3 days, Your Honor. Even Mackenzie was fasting, was eating.
Even Jesus was
Yes, Your Honor. So we really beg. This court is to be used to extend that inhumanity. That is what they are trying to do. And we beg this court, with the powers given to you by the Constitution and the people of Kenya, to give us the chance, Your Honor, to enjoy that. He's not at a flight risk. He's an honorable member of parliament, as indicated by the Young. Those are the words he's used, honorable member. And the rest are equally Kenyans. They will come to court. You can put conditions, Your Honor. They will abide by all that. They are willing to abide by all that. Your Honor, lastly, the first accused, Your Honor, is not well. He's actually not well, and I wouldn't want to take a lot of time. He's been denied access to medicine, which he was taking, and I'm so sure he needs to go to hospital after this. So we'll be begging also that is considered, Your Honor. He has a special physician who sees him at Nairobi Hospital. That is all, Your Honor. Maybe my sister, just for gender balance, give her just 1 minute. Thank you.
Thank you very much, Your Honor. There's a maximum.
Yes. He has not taken water for 3 days. In fact, yes.
Yes.
Pardon? I've actually, we went to Anguru police station in the morning. We were there even yesterday. We were dispersed. Even advocates couldn't access. But today I've been with him at the basement cells. That's the first time we've been able even to access him. That's how inhuman this has been. He has not taken his ear and talk, and I've confirmed that from him. And I believe all of us. Your Honor, the conditions down there, and I really empathize with the officers here. They are strict instructions. Even for us to gain access, it wasn't that easy. I even tried to call my colleague. Ryungu is very good at helping us in those issues. But
Your Honor, we attempted to carry water from the gate. We could not be allowed to come in. So we could not be allowed by the police officer to come in with anything.
What Mr. Okat is not telling you is Babu Owino has been shakaholat for the last 3 days.
No, no, but there was also a brief the police officers treated them very well. So I'm wondering what measure of treatment was that? I mean, in 1 minute here he's saying they're not treated, but he treated and said the officers were very professional and treated.
Your Honor, I'll deal. No police officers are my plan. I'll deal. I'll tell you.
Thank you very much, Your Honor, for the protection and guidance. The 2010 Constitution that was passed in this country is one of the best documents we have in the country. The act by the prosecution is actually to more of mutilate than safeguard, and we ask this honorable court to safeguard the interests, especially of the accused persons, in line with Article 49 and also Article 50, which gives the right to fair hearing. There's a maxim that says, he who comes to equity. Sorry. Must come with clean hands. And I wish to submit that the prosecution has not proved that they are coming with clean hands. From the time the first accused person was arrested to the time he has been presented to court, He was denied the right to representation. He was denied access to the basic fundamental rights accorded to each Kenyan. The prosecution, in their own domain, have judged the accused persons and decided to be the judge and the jury. The accused persons, like it's been told by my colleagues, have not been able to hit their whereabouts, especially for the first accused persons, was not clear, even his legal representation. We have been to different police stations from the time he was arrested. And the key question to the prosecution thus is, an accused person has rights safeguarded in this constitution. Why was the Honorable Babu Owino kept away from his legal team as enshrined in the constitution? Why was the family not made aware of his whereabouts? And why was he not arraigned in court as per the Article 49F, which talks clearly on the procedures on how to deal with an accused person? Therefore, it is my humble submission that the prosecution have not proven to come with clean hands, like I said. It took them from the time they arrested the accused person to today at 5:20 to come up with this affidavit that is full of assumptions, innuendos, and presumptions. If you look at the affidavit,
Your Honor, just for guidance, I don't like it. I just Owino'S director indicated that it should have been done by 6, so the prosecution ended up being curtailed. So just be direct on whether there's a real way this
She's winding up.
as she said, equity comes, still comes to
equity must come with clean hands.
So even as we require equity.
You can seek 4 hours to reply.
Yes.
Everything that is being said is remaining on record, so you will not need to repeat
Yes.
what another council has been saying.
Okay. Much obliged, Your Honor. So, in parting short, my humble submission to this honorable court is that the accused persons are not at flight risk, and that the affidavit presented before this honorable court does not prove or necessitate reasons why they should be denied bail, and therefore I request this honorable court to protect, uphold, and safeguard the 2010 Constitution. Thank you, Your Honor. I would like to call my senior, Owino'S, to order.
I will not take too much of your time, Your Honor. I appreciate that you have spent so much of your time already for the day. Except that what is before you, Your Honor, is a very fundamental issue that goes to the heart of rights that are guaranteed and protected under the Constitution of Kenya and under the Bill of Rights, no less. That bill, Your Honor will appreciate, is not just an ordinary chapter in the Constitution. It essentially is the heart of this Constitution. You violate any of the provisions of that chapter, you essentially snuff out the life of this Constitution for all we know it to be. And I say that, Your Honor, with great respect, because as a practitioner, as an officer of this court, which I believe Your Honor has been before ascending to this very hallowed position in the judiciary, we have a duty, Your Honor, to enforce and uphold and defend this Constitution. And in the course of doing so, particularly with the division of labor within our courts of law, as you deal with these questions every other day, Your Honor, sometimes the detail of it and the weight and significance of some of the provisions of this Constitution will be lost. And most of the time, inadvertently. And I say that, Your Honor, because it is now becoming a norm that the agencies that have been created under this very Constitution, and under the terms and conditions enshrined in this Constitution, are now repeatedly and so brazenly violating cardinal rules they are repeatedly, Your Honor, and so brazenly violating cardinal provisions of this Constitution that we as a people agreed will determine the relationship between those whom or to whom we delegate authority to exercise on our behalf, and us or we the people, and between those agencies intersect. They are violating the common law. And that is very critical and important, Your Honor. It is critical because as I started my submission, this constitution is the lifeline of the existence of this country as a nation state. You snuff life out of this constitution and you invite chaos and anarchy in the manner in which we coexist. And so the violation of this constitution, particularly by those to whom we delegate authority, cannot, and my lord, cannot, this must be taken very seriously, cannot be taken lightly. And that is why I said, as I started, Your Honor, and I said it with utmost humility, that in the course of our ordinary practice, particularly before these specialized divisions of the court, it is very easy to lose the detail, the weight, the significance, the nuances, the detail, the significance, the nuances of some of the provisions of this Constitution as we intended them to operate. So that, Your Honor, it has now become a very sickening trend that police officers, despite express mandatory provisions of this Constitution that proscribe the holding of detainees for more than 24 hours without compelling reasons, will very comfortably appear before you hours after they have violated a mandatory provisions of the Constitution and present an accused person before you, and then without batting an eyelid, ask you for permission to hold them for even a longer period of time. Your brother, the Chief Justice Emeritus William Mutula, coined it very interesting. The Utadu attitude. That an agency created under this Constitution, exercising powers under this Constitution, presumed to be aware of the proscriptions and the prescriptions of this Constitution, can violate it and then come before you and ask you to perpetuate that violation by granting them more time to hold accused persons for an even longer period of time. Your Honor, before you are just these two documents. Your Honor, there's a charge sheet and there's an application. to hold these accused persons for a further period of time, and specified time for that matter. You can see the mischief. They're even asking you to just grant indefinite leave for them to hold these accused persons for an indefinite period of time. And Your Honor, just scan through this document. Not a single explanation has been attempted for why these gentlemen are being brought before you more than 24 hours after they were arrested. The Inspector General of Police has not bothered to provide the Director of Public Prosecution with any reasonable explanation, or any explanation for that matter, why these gentlemen were held for that long. And the Director of Public Prosecutions, who under this Constitution is supposed to exercise Your Honor, can I take just 10 more, please? Well, Your Honor, at the heart of these submissions before you is a freedom of gentlemen here who have been held incommunicado for more than 24 hours. I think they deserve just that extra 10 minutes. Your Honor, the Director of Public Prosecutions, an office created under this Constitution, who is supposed to exercise independent oversight as a countervailing measure deliberately created by this Constitution, has approved a charge sheet also granted. Yes, has approved a charge sheet, Your Honor, which does not, in fact, has not only approved a charge sheet, has actually caused to be drawn an application to detain the accused persons and therefore perpetuates violations against the Constitution without even bothering to inquire from the Inspector General of Police on whose behalf these accused persons were arrested. Why have you been holding them incommunicado for more than 24 hours? And that points to another lapse in the respect for and enforcement of the Constitution of Kenya, which I have been my remarks earlier, said pose grave danger to our continued existence as a rule of law country. What does the DPP do instead? They also brazenly even attempt to fill the gaps for the DCI or the IG by even attempting to adduce evidence from the bar. Evidence that is not even in the affidavit of the corporal who purportedly has the knowledge of first-hand information for why this accused person should be held any longer than is necessary. Where does that leave the policy or constitutional objective for why the DPP was created as an independent office to check the Inspector General of Police in the discharge of his mandate? A danger, that is a danger to the common bond that I alluded to, that this court must guard against. And my lord, all that I have said summarize into this very simple submission. We are before you seeking reasonable bail terms for this gentleman, the accused person. Your Honor, does the conduct of the IG, does the conduct of the DPP count for something as you consider my learned friend, Ms. Asha Bashir, has submitted to you that he who comes to equity must come with criminals? The conduct of the DCI, the conduct of the DPP that I have outlined in very brief terms before you, does that, Your Honor, count for something? Does it hold any weight in your decision or in your consideration of the application pending before you for the detention of these accused persons for a day longer? It surely must. The misconduct that I have alluded to is not just any misconduct. They are violations of the Constitution. Article 2 is very clear in that regard. Any violation of the Constitution, they may not have any fatal effect to the charges before you, but it surely must have some effect and weight on your discretionary powers in considering an application for bail and for bond. That said, Your Honor, the law on bail and bond applications is fairly well settled, and I will not rehash that law or the principles that are applicable, save to invite you, Your Honor, to always bear in mind the policy guidelines by the NCAJ on bail and bond of 2015, and in particular, the purpose or utility of bail in a criminal prosecution such as this. That utility, again, Your Honor, is fairly straightforward, and I will not rehash it. I just want to emphasize on one point, and that is the burden of the prosecution in demonstrating compelling reasons. Compelling reasons why an accused person should not be denied bail or bond. Again, it is fairly well settled, Your Honor, that that burden reposes in the prosecution. Only shifts to the accused persons where compelling prima facie reasons are demonstrated to your satisfaction. Your Honor, compelling reasons are questions of law and fact, and therefore can only be presented to you either by evidence or by reference to specific provisions of the law to justify the application of the order sought. Allow me to concentrate on just these two documents. Most of that.
I have tried to limit time so that we do not sit at night. Hours of darkness begin at 6:30.
You know, we start here up to 4 in the morning.
Let me finish. So we are going to start at this point. Tell us some issues that are related because we will also need to.
Secondly, Your Honor, they are members of Azimio. Third, they are all politicians. Fourth, they all come from the Luo ethnic community. Fifth, Your Honor, this is a proper ethnic political profiling.
You know, with all due respect.
Say 5 minutes, I've only 2 minutes. Your Honor, this affidavit has no date. That's the second line, when it was sworn. This affidavit is as old as 2017. It is the same affidavit that was used to arrest the ruling class now. From 2017 to 2022, it's the same affidavit. And all those that were charged based on this affidavit, their charges were withdrawn. The court should take judicial notice. That the same police officers who swore this affidavit came to court and said they were forced.
So your objection to that line with respect.
That is judicial notice of it.
The officer that defamed to this affidavit is before court. I haven't seen him ask Mr. Omari to talk about on his behalf. We just pray that that last line be ignored.
No, Your Honor, it is me who represents them when the DPP wants to charge them. I'll give you specifically to the officer who swore the affidavit of the deputy president. When that affidavit was disowned, the officer came to court and said he signed the affidavit under duress. It's specific and it's on the court.
So our clarity is that for purposes of today, the IO that swore this affidavit is before court. He has not spoken to Mr. Omari. Mr. Omari might have done very well in other cases, but this affidavit has not been said to have been sworn under duress. That's the only clarification I'm making. For today,
Your Honor, I'm giving Mr. Witty the perspective that come 2027, the same will be disowned that it was signed under duress. For now, it will not be disowned. So that the court, as it is, it looks at the whole political context. Lastly, Your Honor, on this affidavit, I want to bring to the attention of this that it is only the judiciary that is going to protect Kenyans. A great responsibility is on this independent arm. The political dwells outside should not be criminalized. And we urge this court to safeguard and remove the political contests from criminal issues. This is a political matter before you. Deal with it the way it is. So, Your Honor, out of that 5 minutes I've finished, I allow the President of the Law Society of Kenya, before he removes me from the role of practicing, to talk.
Your Honor, with your very kind permission, I recognize the predicament. Yes, sir.
That tells you what is happening, Your Honor, in this court.
Your Honor, I want to begin by saying I do not envy the position you find yourself, and neither do I envy the position that the prosecution finds itself. You don't know what you are being asked to do by the prosecution.
They are lighted. cause more harm. To the security of the country. I also wish to draw your attention to paragraphs 7, 8, and 9, and 10.
Unlawful assemblies taking place, which have led to destruction of property. And therefore, what the prosecution is saying for this court is that the compelling reason here is that even as we talk, or even as we submit before this court, there are certain acts of destruction that are ongoing.
Your Honor, I hate to interrupt my very good friend, Mr. Biungu, but you have limited time and Mr. Biungu is actually giving evidence which is nowhere in the affidavit. And I know he knows that. I've tried to figure it out, but my seat is becoming hot. I think let him be justice.
Here I've had my mandate for this. And it is the hotness that we are stating that it is a compelling reason that the court should concede. Secondly, on the other, with the time I have, the other authority that the prosecution wishes to rely on is the authority reported to Libya, Chelagat Kipyotich versus the Republic. Criminal case number 2001. Delivered by Sophie Emily Kodir at the High Court in Calcutta. Also, this particular authority gives us submission that again, one of the compelling reasons that we have submitted to our affidavit, and which is cited on the second page, is that again, where the accused persons are likely to commit further offenses. And secondly, where the accused persons, Your Honor, are likely to obstruct the cause of justice. Your Honor, under Article 24 of the Constitution, the right and the principle that the court highlighted this true authority to grant the prayers that we have so far today. That is all.
I'll just have a brief address, then I'll invite my nine friends to address you on some few aspects. I will address you on the I'll address you on the aspect of the pre-arraignment detention in respect of the first accused person, to which the prosecution is guilty of, and further guilty of the duty of non-disclosure. The first accused person was arrested on the 18th was arrested on the 18th at 0900 hours, that is 9 p.m. at JKIA when he was en route from Mombasa, 18th of July at 9 p.m. or thereabouts. He was then taken to, driven all the way to Kirinyaga County and detained at a police station called Wanguru Police Station. While there, Your Honor, he was denied his rights to make any contact to either his family members or his advocates. He spent the whole day there yesterday. Never ever even informed of the reason for the arrest. I'm addressing the violation of Article 49 as I address you. He was denied right to access to counsel. And most fundamentally, he was denied the right to be produced before a court of law within 24 hours. This is a time at around 5 o'clock that 5 o'clock on the 20th of July that the accused person has been able to see a judicial officer or to appear before a judicial officer. There's no explanation that has been adduced why all that transgression had to take place. It's always the duty of a trial court it's always the duty of the trial court to inquire on that particular aspect. As and when the same is brought to the attention of the court. Pre-arraignment detentions were outlawed, and Article 51 speaks to that fact. And the case in the court, the High Court in the case of Musa Bwagwa versus Mwanasi and 9 others, for the Chief of Kenya Defence Force, EKLR,
The case of
Musa Mwabwaga, that is MBWAGWA, Mwanasi, and 9 others, versus the Chief of the Kenya Defence Force and others, 2021 EKLR. That aspect of pre-arrangement detention was addressed. And the High Court said it was unconstitutional. And therefore, a charge that is premised on a violation of the Constitution, the court ought to interrogate the integrity of that charge and the propriety of that charge. Even in the affidavit that they have brought before you, they have not addressed that aspect. As a panel, the court is called upon by Article 23, by Article 3, to defend this constitution. Article 10 enjoins the court to uphold the Bill of Rights and the rule of law and a just society. Article 27 enjoins the courts to ensure, Article 27 enjoins the court to ensure that there is equal protection of the law, equal enjoyment of the law, and equal benefit, and outlaws any form of discrimination. We need an answer. Why was Honorable Babu Owino not brought before court within the prescribed period? Number 2, whether a charge that is premised, I'm pending off. Oh, sorry, Your Honor. The answer that we are seeking is why he was not brought before the court as decreed by Article 49, clause 2F. Number 2, whether a charge that is premised on a violation of the Constitution has legal propriety, and whether the same can be the premises for denial of bail or bond. Mr. Okachi, your question.
Yes, Your Honor, I will start by indicating, Your Honor, that it is true that actually not only the first accused person, but all the accused persons are being arraigned before you, Your Honor, outside the mandatory 24-hour limit. Your Honor, the 5th and 7th accused persons were arrested on Monday the 17th day of March 2023. So that we are just shy of the 5 working day period, with the 6th and 2nd accused persons being arrested on the 18th, alongside the 1st accused person. Your Honor, we will not belabor this fact because we will pursue it at the High Court in terms of the violations, Your Honor. But that is important because it tells you a lot as to why we are even addressing you at this time, Your Honor. Your Honor, what has happened, and in a nutshell, there is a skit that has been written and Your Honor, the duty of the investigators and with a lot of respect to the battalion of prosecutors, senior prosecutors, is just to ensure that these accused persons fit that skit. Your Honor, there is no iota of evidence that has been placed before you. Either through their affidavit, Your Honor, or the oral arguments that suggest that there is any compelling reason, Your Honor. None whatsoever. Your Honor, if you look at what they have attempted to indicate as compelling reasons, Your Honor, and that is from paragraph 7 to paragraph 12, Your Honor, you will see there's a repeated use of the word reasonably believed. Reasonably believed. But you are not being told, Your Honor, reasonably believed by who to sustain this particular very heavy averment. Who is this who is reasonably believing, and on what basis? You do not have that. Your Honor, in fact, maybe this may not go on record, but this is the first affidavit I've seen from, HSC Victor Juma Witi that has no annexure at all. The very first one, I've never seen. And that tells you there's nothing. Witi can never do such an affidavit. There's nothing.
You know, for clarity of record, the affidavit is done by the investigating officer. If it is okay, Your Honor, but you read it for yourself, and I
agree, he cannot do that. However, Your Honor, you will notice that even on the substance of the charge, Your Honor. Yes. it is my learned, but he has clarified, so I leave that point. But Your Honor, if you look at even the charge itself, to show you how they have actually stretched to the point of breaking a back, that is what the prosecution has done. Your Honor, they are telling you in very good English that these events happened on the 7th and on the 18th day of July. 18th, 2 days. On the 7th day of July and the 18th day of July. That is on the particulars of the offense. And Your Honor, they are telling you further that these events happened at Kamukunji. Your Honor, they have, and this is common knowledge even to them, they have admitted that Babu was, the first accused was arrested at JKIA. On the same 18th, at around 10, because he landed at 21, 25 hours. So Your Honor, the question is, do we have two Babu Owino'S? Does he have a clone that was at Kamukunji that day? Your Honor, it's able for the court's eyes, the ticket that says clearly he was landing at 21, 25. Your Honor, if you look at further to demonstrate the fact that there is no compelling evidence, and indeed, even the substance of the charge is something that the court ought to look at in admitting the accused persons to bond. Your Honor, I'll refer you to paragraph 7. Your Honor, they are telling you, and my learned friend Mr. Lindu has told you that there are people who have been rioting or who have been picketing, especially where the first accused person represents that constituency. So that is the compelling reason we are being told. Your Honor, there is a decision or a ruling by your brother, and that is the Honorable Justice Mugambi. Your Honor, that is in the case, if I may. In the case of Edwin Sishana Amboso versus LSK, and for others, we have provided that to yourself and to the prosecution. That is HCC petition 255 of 2023. Edwin Sishana Amboso. Your Honor, it says in order 2 and 3, and I want to wind up at that point, that it is the responsibility of persons who have announced and organized the say demonstrations to provide guidance and leadership to the participants. Your Honor, the first accused person is not even a principal in the Azalea coalition. He wishes he would have been, he's not. And there is no evidence that has been given that he organized any of these protests. Which in any case, Your Honor, remains legal. It remains legal because your brother declined to injunct the said expression under Article 37. Your Honor, Order 3 is also very important. It says acts of violence and destruction are personal, and the relevant authorities must deal with individuals. Acts of violence or destruction of property are personal crimes. So it cannot be a crime where vicarious liability, like the prosecution, is fine to appeal. Your Honor, the charge that has been prepared, Your Honor, the history of this charge is very important, and I think this court will bring this matter to a rest. Your Honor, the Section 77(1) of the Penal Code, Your Honor, was brought into our laws, Your Honor, in 1960 as an amendment. So that it didn't originate from the Britons. It's something that was brought here by the Britons themselves. It wasn't in their own laws. And the purpose of that, Your Honor, was to ensure that this country does not get independence. It was to deal with the Mau Mau freedom fighters. That was the purpose of this particular session that the DPP is actually telling us to use today. It was to suppress. So that is what this court is faced with in terms of this charge, Your Honor. It is to take us back to those days and those people who never wished this country to get independence. That's exactly the essence of this charge. And Your Honor, you will not find even authorities. I think people have been shy to use this section. You will not find authorities in terms of this section. Courts have been shy, prosecutors have been shy. But today, we are at the day where it can be brought in broad daylight. We will deal with it, Your Honor, at a different forum. As I finish, Your Honor, I would want to Your Honor, I will heavily beg you, and that's why I'm trying to limit these submissions, Your Honor, to know that the first accused person, and I believe even the rest, but for him, he has not eaten, Your Honor, for 3 days. Not eaten, not taken water. 3 days. And because of where he was incommunicado, 3 days, Your Honor. Even Mackenzie was fasting, was eating.
Even Jesus was fasting.
Yes, Your Honor. So we really beg. This court is to be used to extend that inhumanity. That is what they are trying to do. And we beg this court, with the powers given to you by the Constitution and the people of Kenya, to give us the chance, Your Honor, to enjoy that. He's not at a flight risk. He's an honorable member of parliament, as indicated by the Young. Those are the words he's used, honorable member. And the rest are equally Kenyans. They will come to court. You can put conditions, Your Honor. They will abide by all that. They are willing to abide by all that. Your Honor, lastly, the first accused, Your Honor, is not well. He's actually not well, and I wouldn't want to take a lot of time. He's been denied access to medicine, which he was taking, and I'm so sure he needs to go to hospital after this. So we'll be begging also that is considered, Your Honor. He has a special physician who sees him at Nairobi Hospital. That is all, Your Honor. Maybe my sister, just for gender balance, give her just 1 minute. Thank you.
Thank you very much, Your Honor. There's a maximum.
Yes. Yes. He has not taken water for 3 days. In fact, yes.
Yes,
Pardon? I've actually, we went to Anguru police station in the morning. We were there even yesterday. We were dispersed. Even advocates couldn't access. But today I've been with him at the business cells. That's the first time we've been able even to access him. That's how inhuman this has been. He has not taken his ear and I've confirmed that from him. And I believe Your Honor, the conditions down there, and I really empathize with the officers here. There are strict instructions. Even for us to gain access, it wasn't that easy. I even tried to call my colleague. Ryungu is very good at helping us in those issues. But
Your Honor, we attempted to carry water from the gate. We could not be allowed to come in. And so we could not be allowed by the police officer to come in with anything.
What Mr. Okat is not telling you is Babu Owino has been in Shakahola for the last 3 days.
No, but there was also a brief that the police officers treated them very well. So I'm wondering what measure of treatment was that? I mean, on 1 minute here he's saying they're not treated, but he treated and said the officers were very professional and treated.
Your Honor, I deal. No police officers are my plan. I deal. I intention.
Thank you very much, Your Honor, for the protection and guidance. The 2010 Constitution that was passed in this country is one of the best documents we have in the country. The act by the prosecution is actually to more of mutilate than safeguard, and we ask this honorable court to safeguard the interests, especially of the accused persons, in line with Article 49 and also Article 50, which gives the right to fair hearing. There's a maxim that says, "He who comes to equity." Sorry. must come with clean hands. And I wish to submit that the prosecution has not proved that they are coming with clean hands. From the time the first accused person was arrested to the time he has been presented to court, he was denied the right to representation. He was denied access to the basic fundamental rights accorded to each Kenyan. The prosecution, in their own domain, have judged the accused persons and decided to be the judge and the jury. The accused persons, like it's been told by my colleagues, have not been able to hit their whereabouts, especially for the first accused persons, was not clear, even his legal representation. We have been to different police stations from the time he was arrested. And the key question to the prosecution thus is, an accused person has rights safeguarded in this constitution.